Hello, lawyers and learners. Welcome to Drug Law India. This is the third lecture in our Hindu law series. In the previous lecture, we discussed the sources of Hindu law. We saw that Hindu law developed from ancient texts such as Shrutis, Smritis, commentaries and digests, customs and usages, legislation, and even judicial precedents. That previous lecture is important for today's topic because today we are going to see how commentaries and digests actually shaped Hindu law in different regions of India. The topic of today's lecture is Mitakshara and Dayabhaga School of Hindu Law. At first, this topic may look heavy. There are many terms, there are many differences, there are also sub-schools and case laws. But do not worry, we will understand it step by step in a very simple and connected manner. By the end of this lecture, you should be able to clearly understand what Mitakshara is, what Dayabhaga is, how both schools differ from each other, why Mitakshara has sub-schools, what happens when a family migrates from one region to another, and how important cases explain these principles. Let us begin with the basic idea. In Hindu law, the word school does not mean a school building. It means a legal tradition. Different jurists interpreted ancient Hindu texts differently. Their commentaries became authoritative in different regions. Because of this, different schools of Hindu law developed. Mitakshara and Dayabhaga are not two different religions. They are just two different legal approaches within Hindu law. They mainly differ in matter of ancestral property, coparcenary, partition, succession, survivorship, widow's right, and heirship. Now let us understand the two schools in detail. First is the Mitakshara school. Mitakshara is a more widely followed school. It was followed in most of the India. It is based on the work called Mitakshara written by Vijnaneshwara as a commentary on Yajnavalkya Smriti. In the last lecture, when we discussed sources of Hindu law, we saw that commentaries were an important source. Mitakshara is a perfect example of that. It is not a statute, it is a commentary. But because of its authority, it became foundation of a major school of Hindu law. Now, what is the main feature of Mitakshara? Right by birth is the main feature of Mitakshara. Under Mitakshara, a son acquires an interest in ancestral property from the moment of his birth. Not only the son, but also the grandson, the great-grandson acquires interest by birth. So if ancestral property exists in family, the son is not merely waiting for the father to die. The son already has an interest in the property by the virtue of his birth. This is the foundation of Mitakshara joint family and coparcenary system. Now let us understand the Dayabhaga. Dayabhaga is mainly followed in Bengal. It is based on the work called Dayabhaga, which was written by Jimuti Vahana. Dayabhaga takes a different view. Under Dayabhaga, the son does not acquire the same rights by birth in ancestral property. His right generally arises only after the death of the father. So during the father's lifetime, the father has greater control over the property. The son cannot demand partition in the same way as under Mitakshara because his ownership has not opened in the same manner. Now we come to the core difference between Mitakshara and Dayabhaga. If you understand this one line, the entire topic becomes very clear. Mitakshara says birth creates interest, whereas Dayabhaga says that death opens succession. This is the heart and the core of the topic. If you understand this, if you keep this in your mind, you will understand each and every point of distinction between both the schools. In Mitakshara, the son gets an interest because he is born into the family. In Dayabhaga, the son's right generally arises when succession opens after the father's death. So Mitakshara is birth-based, Dayabhaga is succession-based. Now let us understand the four ideas that explain the entire topic. The first idea is birth or death. Mitakshara gives importance to birth. Dayabhaga gives importance to death and succession. The second idea is coparcenary. Under Mitakshara, coparcenary arises by birth. A son becomes a coparcener because he is born in the family. Under Dayabhaga, coparcenary does not arise by birth in the same way. It arises only after the father's death when the heirs inherit jointly. The third idea here is that of survivorship. Under Mitakshara, survivorship is important. If one coparcener dies, his interest may pass to the surviving coparceners. Under Dayabhaga, survivorship does not operate in the same manner. The property devolves by succession in Dayabhaga. The fourth idea is that of the basis of heirship. Under Mitakshara, heirship is based on blood relationship. The closer blood relative is preferred in Mitakshara, whereas in Dayabhaga, heirship is based on spiritual benefit. The person who can offer spiritual benefit through what is called as Pindadan is preferred. So these four ideas give us the structure of the whole lecture: birth or death, coparcenary, survivorship, and heirship. Now let us understand the meaning and origin of the two schools in little more detail. Mitakshara was written by Vijnaneshwara. It was a commentary on Yajnavalkya Smriti. The word Mitakshara is commonly understood to mean measured words. Because Mitakshara was accepted in most part of India, it became a dominant school of Hindu law outside of Bengal. Its important contribution was the idea that son acquires an interest in ancestral property by birth. The single idea affects almost everything within this: the father's power, the son's right, partition, coparcenary, and survivorship. Dayabhaga was written by Jimuti Vahana. It became the main authority in Bengal region and some parts of Tripura, Assam, and even Orissa. Under Mitakshara, it does not give the same birthright to the son in the ancestral property. Instead, the right generally arises after the father's death. So, if we compare their origin and approach, Mitakshara is a commentary that became dominant in most of the India. Dayabhaga is a digest that became dominant in Bengal region. Mitakshara looks at birth, Dayabhaga looks at the succession. Now let us understand the difference between Mitakshara and Dayabhaga. Please do not worry about memorizing each and every point while listening. Just understand the logic. A PDF containing a detailed comparison between two schools will be given in the description or the website. You can download it and revise it later. For now, just follow the explanation. The first difference is the basis of inheritance. Under Mitakshara, inheritance is based on what is called as unobstructed heritage, that is Apratibandh daya. This means that the son's right is not obstructed by the father's existence. The son gets an interest by birth. Under Dayabhaga, inheritance on the other hand is based on obstructed heritage, also called as Sapratibhandh daya. This means that the son's right is obstructed during the father's lifetime. The right arises only after father's death. So second key difference is right by birth. Under Mitakshara, a son, grandson, great-grandson acquire a right by birth in ancestral property. This is why Mitakshara creates a strong joint family and coparcenary structure. Under Dayabhaga, the son does not acquire ownership by birth in the same manner. His ownership generally arises after father's death. The third difference is coparcenary. Under Mitakshara, coparcenary begins by birth. This means that coparcenary can be large because every birth in the family line may create a new interest. Under Dayabhaga, on the other hand, coparcenary begins only after the father's death, when the heirs inherit jointly. So, in Dayabhaga, coparcenary is comparatively smaller and succession based. The fourth difference is the father's power over property. Under Mitakshara, the father's power over ancestral property is limited. Why, you may say? This is because the son already has the right by birth. The father cannot ordinarily alienate ancestral property as if he were the absolute owner of it. He can do so only for legally recognized reasons, such as legal necessity or benefit of the estate. However, his self-acquired property he can alienate anytime in both the schools. Under Dayabhaga, the father has wider powers during his lifetime. Since the son does not have the same birthright, the father's control is stronger. The fifth difference is the right to demand partition. Mitakshara says that because son has interest by birth, he may demand partition during the father's lifetime, subject to rules and limitations. Under Dayabhaga, the son cannot demand partition during the father's lifetime in any manner. This is because his right has not opened in the same way as in Mitakshara. The sixth difference is that of survivorship. Under Mitakshara, the doctrine of survivorship applies to coparcenary property. This means that when one coparcener dies, his interest may pass to the surviving coparceners. Under Dayabhaga, property devolves by succession on the other hand. Survivorship does not operate in the same way. This leads to an important difference regarding the widow. Under traditional Mitakshara law, the widow could be excluded by the survivorship rights of other coparceners. She might have a right of maintenance, but she would not necessarily inherit her husband's share. Under Dayabhaga, because succession is important, the widow may inherit the share of her deceased husband. So Dayabhaga gave comparatively stronger position to the widow in this respect. The seventh key difference is ancestral and separate property. Under Mitakshara, there is a clear distinction between ancestral property and separate property. Ancestral property is important because the son can acquire a right in it by birth. Under Dayabhaga, this distinction is less rigid because the son's right generally arises after the father's death. The eighth difference is the mode of partition. Under Mitakshara, partition is generally according to branches of the family. This is called as per stripes. Under Dayabhaga, partition is generally according to individuals. This is called as per capita. The ninth difference is the basis of heirship. Under Mitakshara, heirship is based on blood relationship and nearness of blood. This is called propinquity. Under Dayabhaga, heirship is based on spiritual benefit. The person who offers greater spiritual benefit through what is called as pind dan or pind offerings is preferred. Now, if we step back, all these differences are not separate and disconnected. They all come into existence through the same foundation, and that is what I am repeating over and over again, that Mitakshara begins with birth. That is why it creates birthright, coparcenary, survivorship and blood-based heirship. Dayabhaga, on the other hand, begins with succession after death. This is why it gives more control to the father during his lifetime and gives importance to succession and spiritual benefit or pindadan. Now remember one important thing. Dayabhaga does not have sub-school in same way. Mitakshara does have sub-schools. In fact, it has 4 sub-schools. So let us understand the sub-schools of Mitakshara. The reason Mitakshara has sub-school is simple. India is a large country and it had several different regions. Different regions relied on different local authorities, and every place would have their own traditions. So because of this regional differences, Mitakshara developed several sub-schools. There are basically 4 of them that are important: Dravida School, Maharashtra or Bombay School, Banaras, and finally the Mithila School. Do not worry about the names of all the text and authors under each sub-school that are given on the web page. For this lecture, we need to focus on authorities that are important for understanding the case law. The first important authority is Mayukha. Mayukha is connected with Maharashtra sub-school. This is important because migration cases that we will discuss in this lecture will involve some Maharashtrian Brahmin families. When such families migrated to another region, courts had to decide whether they would continue to be governed by Maharashtra or Bombay School. So whenever you hear Mayukha, connect it with Maharashtra or Bombay School. The second important authority is Veera Mitrodaya. Veera Mitrodaya is connected with Banaras School. This becomes important where Mitakshara is doubtful or incomplete on a point. In such situation, courts may use Veera Mitrodaya to explain the rule more clearly. So for our case law distinction, remember just 2 connections. Mayukha is connected with Maharashtra or Bombay School. Veera Mitrodaya is connected with Banaras School. That is enough to understand the cases without getting lost into the difficult names. Now you may think, what happens if a person or family residing in one region migrates to another region? Suppose a family originally belongs to Maharashtra, then it migrates to some region somewhere in Banaras School. Does that family automatically will be governed by Banaras School? Does it have to adopt the new sub-school just because it moved to the new place? This is a question of effect of migration. The rule is very practical. Hindu law is personal law. It attaches the person and the family. Therefore, when a Hindu family migrates from one region to another, it generally carries its original personal law with it. Mere migration does not change the school of law. law. Mere residence in the new region does not change it. Even acquiring property in the new region does not automatically change it. To apply the law of the new region, there must be a clear evidence that the family abandoned its old law or adopted the new law. This is because family may shift for business purpose, for doing trade or some other reasons. But shifting residence does not mean that family has given up its legal tradition. The question was answered in important cases. Two similar cases should be discussed together. One is that of Keshao Rao versus Sadasheo Rao, and another is of Balwant Rao versus Baji Rao. Both the cases deal with the same problem. A Maharashtrian Brahmin family had settled in central provinces where the Banaras school was generally applicable. The question was, should the family be governed by Banaras school because it was living in central provinces, or should it continue to be governed by Maharashtra or Bombay school because it was its original personal law? In Keshao Rao versus Sadasheo Rao, the family had migrated from Maharashtra region and had acquired property in central provinces. The argument was that since the family was now living in different region and had property there, the local law should apply. But the court did not accept that view. The court held that the family continued to be governed by Mayukha law. And Mayukha, as we have already seen, is connected with Maharashtra or Bombay school. So the principle in Keshao Rao versus Sadasheo Rao was clear. Acquiring property in another province does not itself change the family's personal law. Now let us see another similar case, that is of Balwant Rao versus Baji Rao. Now the facts of the case are very similar. In Balwant Rao versus Baji Rao also, the issue was exactly identical. A Maharashtrian family had settled in central provinces. The question again was whether Banaras school would apply. The Privy Council held that Maharashtra school will continue to apply. The reason was that there was no proof that the family had renounced its original law. The family had migrated, but the migration alone is not enough. So when we read these two cases together, the rule becomes very clear. A Hindu family carries its personal law after migration. The original school continues. The law of the new region applies only if abandonment of the old law or adoption of the new law is proven. Now let us discuss Girdhari Lal versus Bengal Government, which will be our last case for today that we will discuss. There are 4 cases given here, you can read out, but we will be discussing only 3 in this lecture. So in the case of Girdhari Lal versus Bengal Government, it is about the use of recognized authority to explain doubtful points under Mitakshara law. Here the Privy Council considered the authority of Veera Mitrodaya. As we discussed earlier, Veera Mitrodaya is connected with Banaras school. The important point is where Mitakshara is doubtful, unclear, or incomplete on a point, a recognized digest like Veera Mitrodaya can be used to explain the law. This does not mean Veera Mitrodaya replaces Mitakshara. It means that Veera Mitrodaya helps in understanding and clarifying Mitakshara. Courts also looked and recognized commentaries and digests to understand the correct law that will apply. This again connects us with our second lecture on sources of Hindu law. In that lecture, we saw that commentaries and digests are important sources. Here, we will see the practical use of that principle. When Mitakshara is unclear, a recognized authority like Veera Mitrodaya can help the court interpret the rule. Now, let us summarize the whole lecture. Mitakshara and Dayabhaga are the two principal schools of Hindu law. Mitakshara is based on commentary of Vijnaneshwara. Dayabhaga is based on work of Jimuti Vahana. Mitakshara is followed in most parts of India. Dayabhaga is followed mainly in Bengal. The key difference is Mitakshara says that birth creates interest. Dayabhaga on the other hand says that death opens succession. Under Mitakshara, a son acquires an interest in ancestral property by birth. Under Dayabhaga, the son's right generally arises after the father's death. Under Mitakshara, Coparcenary begins by birth. Under Dayabhaga, Coparcenary begins after the inheritance. Under Mitakshara, survivorship is important. Under Dayabhaga, succession is important. Under Mitakshara, heirship is based on blood relationship. Under Dayabhaga, heirship is based on spiritual benefit or a Pindadan, what we have discussed. Dayabhaga does not have sub-schools in any form. Mitakshara has 4 sub-schools, namely Dravida, Maharashtra or Bombay school, Banaras school, and fourth one is the Mithila School. For case law, remember Mayukha and Veera Mitrodaya are the two authoritative sources. Mayukha is connected with Maharashtra or Bombay School. Veera Mitrodaya is connected with Banaras School. On migration, the rule is that a Hindu family generally carries its own personal law. Mere migration does not change the school. Mere residence into another region does not change the school. Mere acquisition of property in another region does not change the school. Keshao Rao versus Sadasheo Rao and Balwant Rao versus Baji Rao explain this rule about migration. These two case laws show that the migration of Hindu family continues to be governed by its original personal law unless abandoned or adoption of new law is proven. Girdhari Lal versus Bengal Government, the last case that we discussed, explains that recognized authorities like Veera Mitrodaya may be used to clarify the doubtful points under Mitakshara law. So the whole topic can be remembered through one final contrast: Mitakshara birth, blood relationship, coparcenary, and survivorship. Dayabhaga, death, succession, individual share, and spiritual benefit. Once you understand this contrast, the detailed difference become much easier. That completes our third lecture on Mitakshara and Dayabhaga schools of Hindu law. Thank you for watching. Keep learning and keep building your legal concept clearly, one lecture at a time. Thank you.